and welcome to Legally Speaking with me, Tarun Nangia. Today is a very, very important show because the Chief Justice of India, Justice Ramana, spoke at the annual function of the Indo-German Chambers of Commerce about the Indian courts being pro-arbitration. He said that Indian courts not only have a pro-arbitration stance, but also possess absolute independence and constitutional strength to treat all parties equally and foreign entities also. But what was the sense of what he was speaking at the speech is what we are going to speak to our panelists, because we know he's been making a great pitch about arbitration in India, to arbitrate in India. And it is indeed makes one happy that, you have a Chief Justice of India who's going out of his way and speaking about arbitration in global forums and why India should be developed as a hub. What all he spoke, we will take up subsequently on the program. But may I introduce you to my panel first. Justice M.M. Kumar joins us on the show. He is the first president of the National Company Law Tribunal and also served as the Chief Justice of the Jammu and Kashmir High Court. Good to see you again and looking forward to some interesting interventions. I have with me Senior Advocate Ma'am Pinky Anand. She served as the Additional Solicitor General of India. You were seen her on the show earlier. Good to see you, ma'am, and looking forward to some interesting inputs. May I also welcome Advocate Rohan Shah from Bombay. He is an advocate who practices at the Bombay High Court and the Supreme Court of India. Good to see you, Mr. Shah, and looking forward to some interesting inputs as usual. I would like to welcome Advocate Saket Sikri, who practices at the Delhi High Court and the Supreme Court of India. Presently, he happens to be somewhere in the hills, but he's found time and joined us. Good to see you, Mr. Sikri, and looking forward to some interesting interventions. At the outset, let me request Justice M.M. Kumar to make the opening comment before we move on. Over to you, Justice Kumar.
Thank you, Tarun. I think the Chief Justice of India, as you rightly say, is making tremendous efforts to attract the arbitration towards India. He mentioned that Singapore, London, Paris, and other arbitration centers in Europe, they are very expensive. India offers a very reliable system, independent judiciary, and pro-arbitration courts. Independence of the courts. Repeatedly, he tried to dispel the impression that the courts are interfering during arbitration. And he's trying to say that institutional arbitration is being now welcomed, and more and more institutional arbitrations are attracted to India. The fundamental reason, I think, is that after 1996 Act and the amendment which came in 2016 and 19, at the international platform, we have not been seen apprising the foreign arbitration centers that what happens in India. So that lack of connectivity with the foreign centers, I think, is one thought which Chief Justice of India must be having at the back of his mind. So keeping that in view, because large number of amendments which in 2016 and 2019 came also aim at curbing the interference of the courts in the arbitration process. So I think the basic idea is to showcase to the world at large that here is the country which can afford at a affordable rates arbitration, fair arbitration, and come to us. That is the basic fundamental theme of what Justice Ramana has. Then the roots of his statement flows from Section 5, Section 8, and Section 16. Section 5, as everybody knows, unequivocal terms announced that notwithstanding anything contained anywhere in any statute, no court should interfere in arbitration proceedings during the course of arbitration, except in the manner provided in the Act. So Section 5 is an omnibus provision, is a salutary provision which show India's resolve that arbitration would be left free in the hands of the arbitrator. Then Section 8, whenever an action is brought before the courts, then the court finds that there is arbitration clause, valid arbitration clause, can refer the dispute to the arbitration unless there is a doubt with regard to the validity of the arbitration clause. Then Section 16, this is such a Section 16, particularly after the amendment, is broad-based. Arbitrator can decide about his own jurisdiction. Any preliminary objection like limitation or any other preliminary issue, it is not for the courts to decide. It is for the arbitrator to decide. All these features, I think, constitute the basis for the Chief Justice of India to make this statement.
Thank you for that open and explanatory comment on what the Chief Justice of India, Justice N.V. Ramana said. I'll go to Ma'am Pinky Anand for her opening comment on Justice N.V. Ramana.
Well, Tarun, thank you for coming in here. And of course, Mr. Kumar has given a great elucidation on the subject. I might say that this is not the first experience I've had with Justice Ramana's, standing progressively for arbitration and advocating it. And not only advocating it, but strongly, I would say, advocating it. It's very commendable because ultimately, I mean, it's another matter. The Chief Justice of India, the signal that it sends across is across board. One of the starting experiences, aside from the judgments of the Supreme Court, was the recent conference at Dubai, where the Chief Justice of India for the first time visited Dubai and Saudi Arabia. And indeed, that made such an impact that it was unbelievable. And the entire scenario was around, of course, arbitration and promoting arbitration. As you know, with the UAE, we recently signed an agreement whereby the foreign decrees are enforceable, and as far as arbitration is also concerned, that is also coming very soon into being. So that has really moved the way forward into one line. The second aspect, I think, that is very important with Justice Ramana's recent speech at the Indo-German Chambers of Commerce is the integration of Western and the Indian, for example, the Indian subcontinent and the Asian subcontinent for that matter, and the desirability of having a presence here. The whole issue is India is investment friendly. There's no dispute on that proposition. We are inviting investments. Our investments largely overwhelm the global trading in a number of ways. So as far as investment is concerned, it's closely linked to the resolution processes, the commercial matters, whether it's litigation, whether it's arbitration. And it is undisputed again that in commercial matters, arbitration has proved the way forward. So the whole process of Justice Ramana really taking this entire steps to promote a move towards India, to a move towards investment and adjudication being correlated with each other. 3, he's even advocated global mechanisms for arbitration and to try to have that between various countries so that you can actually have global presence as much as, for example, the Indo-German Chambers of Commerce advocated to have a global forum. Of course, he's recently, Chief Justice Ramana has started the Arbitration Center Telangana, which is a move towards the south, and Gujarat also, I believe, is in the process of coming towards an arbitration center. So the question is not only numbers, the question is of passing this message forward to the rest of the world and to us as Indians to say, we have this mechanism available. We've had a couple of bad experiences, there's no doubt on that score, but we've also had Amazon. We've had emergency awards being adjudicated upon and executed without a single doubt, even though the statute itself, there was some ambiguities to some extent, but that has been resolved through a judicial adjudication. So the whole process of promoting arbitration is a mechanism which is better suited possibly to commercial matters than to other mechanisms. And therefore, I think it's an extremely exhilarating experience in hearing him. And I believe we are taking this forward to another couple of jurisdictions very shortly with Chief Justice Ramana too.
Thanks for that opening comment. I'll go to Advocate Rohan Shah at this point. Mr. Shah, Chief Justice of India, Justice Ramana said to the audience at the Indo-German chambers, let me assure you, Indian courts are known for their pro-arbitration stance. Courts in India assist and support arbitration and leave the substantive part of the adjudication to the arbitration tribunal itself. Here you see a Chief Justice going out and messaging to the world, come and arbitrate in India. Do you think he's assuming that role? He has taken it upon himself to push arbitration in this country, not only domestic arbitration, but also international arbitration.
Tarun, I think it's a wonderful advertisement for arbitration in India to have the Chief Justice of India actually playing both ambassador and champion to the fact that India is a nation which draws lots of foreign investment. And he has said that the credibility of that process is tied into the factor that justice delivery system is something that foreign investors can trust. And there, he's so strongly advocated arbitration. The fact of having institutional arbitration centers where there is not only predictability of the process and rules, but also predictability in terms of timeframes. Also, his assurance that the entire system is geared, legislatively through our various amendments and through the approach of the courts, to say that Indian courts will leave it to the arbitration process. And significantly, he's pointed out that that's not just a judicial approach, but that we are increasingly including more and more topics which could go to arbitration, therefore giving full play to arbitration. And I think his two suggestions, one in terms of pre-vetting of contracts, to say that, this will help eliminate all nature of doubt on procedure. And then his situation of saying this geography of arbitrations, which today is investments in developing countries, but dispute resolution in few advanced centers, that needs to be neutralized by creating greater infrastructure in India. And I think what is a very far-reaching statement-like approach even internationally, to say that, all of the international bodies ought to come together to create a confederation or a council for arbitration. I think all of these are very, very strong messages, and emanating from the Chief Justice of India, I think we are going to see a further fillip to the entire arbitral movement in India.
Thank you. And that is a positive note that, arbitration will increasingly see greater acceptance and we will become an arbitral destination. That is, of course, the intention. I'll go to Advocate Saket Sikri for his introductory comment.
Thanks for having me on the show, Tarun. If you remember, a couple of months back, we did a show when the Honorable Chief Justice had inaugurated the Telangana Arbitration Center.
Yes.
And that's when I that was my opening comment then, that Justice Ramana's words are not mere words; they're always in action.
Yes.
And when he opened the when he inaugurated the Telangana Center, it's a very unique center. It is mediation and arbitration. So I remember making some comments as to how we can structure the clauses, whereas certain agreements can be integrated into having centers which can include mediation and arbitration. Now, the message of Justice Ramana has been from the very inception to include arbitration into the mainstream judicial and justice delivery system. The attempt is to include arbitration into courts mechanism. The awards are taken so seriously that they're not interfered by any court of law, as we have seen. The panel on the show has already commented on that fact. So my opening comment is that the Honorable Chief Justice is very serious. He's an ambassador of arbitration throughout. He has sent a message across board, both domestic as well as international, investment and international fraternity, to say that arbitration and an arbitral award is nothing but akin to a court decree and a court order. It will be respected by the courts as much as a court judgment and decree is respected. And this is the message which is imperative. it takes on from it takes care of all the amendments that we have. 2096 we had an amendment, 2015 we had an amendment, then 2019 we had an amendment. All of this shows how serious India is as a nation for arbitration. And then the apex body and the Chief Justice going to various bodies, whether in Singapore, whether in Dubai, or whether in Germany, making a point as to how serious India is as an arbitration is a very positive step and a very positive message for the arbitration culture to develop and for India to have an arbitration friendly atmosphere. So I would think it's a very, very positive state, and we welcome this comment by the Honorable Chief Justice.
I'll go to Justice M.M. Kumar. Sir, you saw that the Chief Justice of India said that we leave the substantive part of the adjudication to the arbitration tribunal. Then after that, interestingly, he went on to say that you can trust the Indian judiciary for absolute independence and inherent constitutional strength to treat all parties equally and equitably. The constitutional courts of India, the high courts and the Supreme Court, have the power to judicially review every act of the government. They can strike down any law that is not in tune with the constitutional principles. They can also set aside arbitrary measures of the executive. So, this is a messaging. I mean, any word that the Chief Justice of India speaks can't be just said like that. He would have mulled upon this. What message was our Chief Justice trying to give?
Well, Tarun, I think, as I said in the opening comments, for example, Section 16, if we take Section 16, because one part of the statement of Justice Ramana has roots in Section 16. Now, Section 16 says that if existence of an arbitration clause is found and that clause is found to be valid, even that jurisdiction is given to the arbitrator.
Okay.
It is not that court will start deciding or the matter will be referred to the court. The arbitrator has been considered competent with regard to for deciding his own jurisdiction. Arbitrator is considered competent to decide with regard to the validity of the arbitration clause. What Justice Ramana is trying to highlight to the world at large, that here is a country where arbitration is given free hand. There is hardly any interference by the court. The court interference, although is very limited, 34, 37, they are there, but 27 is also there, but that is not interference in that sense. But Section 16, I think, then as Madam Pinky Anand has mentioned, Amazon's case. This judgment in Amazon versus future sales, they have recognized emergency arbitration under Section 17.
Yes.
Which is a unique feature. Supreme Court has risen to the occasion, and instead of accepting the argument of this future sales, that it is there cannot be any award before the arbitral tribunal is constituted. That argument rejected. The Supreme Court said that under Section 2, subsection 6, 2, subsection 8, and then Section 19, subsection 2, parties are given full liberty to opt for any rules. So if the parties have opted for the rules of SIAC, Singapore International Arbitration Center, so nothing prevents them, nothing stops them. When it comes to execution and the future sales, they tried to violate the injunction granted. When Delhi High Court was moved, single judge held that it is an emergency award. So if you examine the whole judgment, division bench Delhi High Court reversed the single judge, then matter went to the Supreme Court. Supreme Court held that it is an emergency award. Although word emergency has not been used in section 17, but Supreme Court read out the word emergency award in section 17. That is the beauty. That is the beauty. We are now more and more recognizing Singapore International Arbitration Center, SIAC. Once parties have opted, any institution rules can be adopted. So once that has been done, so you cannot say that it will not be regarded as an emergency award. So it opens up another area. I think Amazon case opens up another area in international arbitration for this country when the Supreme Court has accepted the emergency award, that jurisdiction are there under section 17.
Thank you. Thank you for sharing that anecdote with us. I'll go to Ma'am Pinky Anand for her input on the same issue that I raised with Justice M.M. Kumar.
See, I'll tell you one more thing that I think is very important. I think there has been some kind of, let me speak openly. I mean, there is some kind of Western bias in disputes. And I think we need to offset that. And one of the ways of offsetting is if you have a geographical balance, as the Chief Justice was recommending. That balancing is another feature which was very important. And I think he's pointed it, of course, a little more discreetly than I'm saying so, but I'm being rather open about it for the reason that you have a dispute which is otherwise located, let us say, in the subcontinent, if not in India. And ultimately, you have experts or other arbitrators who are not, one, they may not be domain experts or they may be domain experts, otherwise experts from the Western horizons. You do find some kind of bias that is sometimes inbuilt and some kind of possible, not visible understanding of the complexities involved in a commercial kind of disputes and a functioning within the commercial environment. So I think that balancing is what we are now seeking to achieve. I mean, we've achieved a lot. For example, BRICS, Tarun. The BRICS entire regime is also one of the same principles of achieving this geographical balance between the Western and the Eastern world. Or the developing and the developed world. I mean, even though India by now is more or less developed, but nonetheless, we possibly come within the developing regime. So we do need to balance. We have the investment, we have the funds, we have the inputs, we have the technical expertise, we have the transfer of technology, we have the licensing, we have the non-licensing. So, I mean, in overall circumference, I think this balancing and geographical balancing in making India an arbitration-friendly center, which it is. So one is that feature, which I think has been highlighted by the Chief Justice very well. And secondly, there has been somewhat of some bias against India because of our earlier experiences. So the entire feeling that there'll be judicial interference, which will possibly override the arbitral awards, is something which has been possibly offsetting foreign investors and foreign countries from using India as a destination. So the Chief Justice, as you say, when he sends a message, it goes far and wide. And ultimately that message that today, which is a fact, you find increasingly, please look at the judgments of the Supreme Court. There is less and less interference. I am not saying by any means there should not be interference in arbitral awards. I would not say that because you have to have adjudication possible, and that is the due process of law. So following the due process of law, but nonetheless limiting as we have, as Mr. Kumar rightly said, the laws have also been amended to limit the area of interference. But the judicial visibility in reduction of interference in arbitral awards is a message again that needs to be passed on to all countries to make them understand that we are not only available, not only do we have the infrastructure, not only do we have the means, but we will ensure that arbitral awards and party autonomy is given the highest credence that we can in the country.
You know, just 2 points, what Justice M.M. Kumar said and what Madam Pinky Anand said. There are one very important and practical part I'd like to share my personal experience on this. Very recently, I was interacting with a very eminent and a senior person at the bar at the Delhi High Court. And what the person told me was that doing arbitrations is a pleasure because you get to appear before some of the most eminent judges who were eminent judges as the judges of the High Court, as Chief Justices, or at the Supreme Court level. Justice Kumar is one here. Obviously, we've had the pleasure of appearing before Justice Kumar in the NCLAT and now as an arbitrator. So what gives the strength to the Honorable Chief Justice to say that is not just the court system. The courts will also have to see an award. Now, when you see the arbitrators per se, we've got one of the finest pool of arbitrators in this country. We've had finest judges who've been in the High Court, Chief Justices and the Supreme Court, and even the CJIs, who are today arbitrators. So when the Honorable Chief Justice makes a commitment on behalf of the country to sort of put forth India as an arbitral-friendly country or arbitral-friendly nation, not just the courts, but even the pool of arbitrators are fantastic. We have one of the finest judges who are today the arbitrators. The awards are cast iron. The courts have also, as Justice Kumar put it, and Madam Pinky Anand also put it, how legislative intent is minimalistic interferences by the courts. Now, if the award is by a very illustrious person who knows the law, who's appreciated the evidence and put forth the evidence and the law in an award, it will become very difficult for a court to even interfere. So it's not just a single process of court not interfering with the arbitral process. It's also important as to how illustrious and how the kind of arbitrators we have in this country. So it is a two-way process. The Honorable Chief Justice is aware that not just the courts, but also the pool of arbitrators are fantastic in this country. And that's why such a bold and important statement. It's actually, if you go back to 2016, there was a conference when the Honorable Prime Minister said resolve in India.
Yes.
That resolve in India concept has been truly realized. There is an amendment in 2015 which brought the Arbitration Act towards institutionalizing it, in the sense that the so-called ad hoc arbitrations that we had throughout the country, of course, the actual grievance we had from the arbitral system was that the arbitration is an endless process. By putting the checks and balances under the 2015 legislation or the amendment, that endless process has been put to an end. There is a time period that has been put. Every arbitrator is conscious that he has to give an award within a certain period of time. Then that has further, the limits on the interference by the courts has further been strengthened by the 2015 legislation. And these are the building blocks. And this is what led to today making India as an arbitration-friendly nation. The Honorable Chief Justice is going everywhere and trying to, and actually rightly projecting the image of India as an arbitral-friendly nation. So I would personally feel that this dream of the Chief Justice should be realized soon. This dream of resolve of India, along with the dream of the present Chief Justice of making India as an arbitration-friendly nation, should be resolved. And I really hope that today...
I would like to do a show for the tagline you gave me called Resolve in India. We must run a campaign which says Resolve in India. Now I'll go to Advocate Rohan Shah. Mr. Shah, very interestingly, the Chief Justice of India said that Indian courts do not discriminate on the basis of the country of origin. All are equal before the courts of law in India. Do you see here that Justice Ramana is going out all the way out to give a message to the international community to arbitrate in India?
Absolutely, Tarun. And I think very strongly sending that message. Two fronts. One, as others have repeatedly also remarked, making it very clearly known that Indian courts are pro-arbitration, will interfere as little as possible, and will allow full play to the arbitral process. But also the factor that as a foreign investor, unlike in some jurisdictions where foreign investors have felt an alienation when going up against the state or a local party, that Indian courts have a record of treating equally everyone who comes before them, and that it's the rule of law and the predictability that there will be an impartial assessment of your issues that should draw people to India and have greater confidence in the legal system of India. So I think that combination, that arbitration as internationally known and accepted, very little interference, and should it be required, Indian courts will treat everyone equally and have the ability to pull up government or the bureaucracy if required. So I think all of those very strong messages to not only underline the fact of investments being welcome, but assuring the international investors of fair and predictable treatment.
Thank you. Thank you. So in a sense, you are saying that this was a message for Invest India, basically, to invest in India and also ensure that you arbitrate if there are any disputes in this country.
And I think a reiteration of our very strong legal system, which time and again has proved itself to deliver justice irrespective of nationality or personality.
But I would like to thank all of you for these interesting interventions. Justice M.M. Kumar, Ma'am Pinky Anand, Advocate Saket Sikri, Advocate Rohan Shah, you came, you contributed to the show and also gave us insight on what Justice Ramana said. We'll follow this up in the next fortnight on arbitration. But thank you so very much for joining in. Thank you so very much. This is a pleasure talking to all of you.
Thank you, Tarun.
Thank you. Thank you, everyone. Thank you. Thank you, sir.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.